So now we have some time for questions. We're going to ask that you go to the mic so that we can record everything. I know that means you have to get out of your seat and move, but please come to the mic if you have a question.
Okay.
You can actually take the mic off the stand.
Okay. I'm Steve Pennington. I do disability rights cases. And are you familiar with any case where videos would be taken of a workplace, for example, to deal with the ability of a person with a disability to be accommodated, or to address a safety issue, or maybe the employer is raising that as a defense?
The only answer that I can give you on that is, the answer is no, as to the ADA or situations like that. I have seen workplace videos where they were stuffing dolls with cotton, and the room looked like a snowstorm, and we were dealing with pneumoconiosis and the effect of the inhalation of cotton dust. But I've never seen one where the question of ADA rights or that type of thing were done.
How about constitutional tort cases, prison suicides, excessive force cases? Have you gentlemen ever been involved with those cases, and have you ever taken a videographer into a jail or a prison to show a particular condition, for example, where the person was housed, the cell?
I've had cases of suicides in a jail cell, but I have never seen a video, and I have never gone to the jail with a videographer. But yeah, you get those cases. They're not unusual.
That's two strikes. How about, let me just ask this, how about in Erica's case, for example, did you take any video of her in the hospital? And was that ever something that you thought you would present to the jury, or did you think that might be overreaching? Or I guess the question is, you do day in the life videos, you do settlement videos, but are there other kind of videos that you've used in either an arbitration, a mediation, or a trial to kind of convey the the impact on the person?
Well, let me answer your question and make a couple of comments. We did not do a video of Erica in the hospital. When Erica was in the hospital, she was largely helpless. There wasn't a lot of movement to depict. I believe there were photos. I don't think we ended up showing them. They weren't really terribly important to what we were trying to communicate. One thing that we did do in this case before it was settled is that fellow Brock Harper, who was a physical therapist and who is in Chester County, he would not come to court in Allegheny County, which is 250 miles from Chester County, voluntarily. And so he did agree to go to a video conference center, and we did have him testify live by video conferencing in Allegheny County in state court. And he answered my questions and could have been cross-examined if there had been any questions from cross-examination. So that was the use of video conference in the courtroom in that particular case. On your question about disability cases, there's nothing about what you described that would not be amenable to videography. And Marty very adroitly explained how you can do this for not a whole lot of money. So I would think you could walk into a workplace and video something and have it be useful. But the one danger that you have, though, and you really got to think about this as an advocate, is when I walk into basically the defendant's den and videotape their environment, they can then show that videotape at trial to demonstrate really how wonderful their environment is, their workplace, if it's a prison, the facilities in the prison. And they will obviously stress the fact that this was done by opposing counsel. Opposing counsel thought they were going to do something clever, but it wasn't really all that clever. Similarly, Ed talked about surveillance video. We routinely ask our opponents if they have surveillance video. They're supposed to tell us if they do. If they've taken it, and it's unhelpful to them, we will customarily play it at trial. In other words, here's the surveillance video taken by these folks of our client. They figured he was a malingerer and a cheater. You can see what he can and can't do. Shame on them for taking the video. So I'd be a little bit concerned about walking into a workplace with a video camera for that reason.
I know that Lori McKinley has, who does employment discrimination cases, but I think I'm echoing the comments both Shana made now and Ed made earlier. When you put something down on film, it's there, you've got to deal with the consequences. And also on Ed's comment about like going into a hospital, I have videotaped a lot of physical therapy sessions of my clients in hospitals. You got to do it with dignity, and it's about them overcoming, not about them being defeated, that you want to have as a theme. And you can capture that at a lot of stages of a person's rehabilitation. And I like to try to capture it as many places as I can, but it's about overcoming. So do I have videos of a client, laying in a bed? No. I mean, it's about them doing something like Joe here. He gets down to the end and he's really happy, and then he collapses because he's pushing himself. That's what you want to capture, and you can do that at a myriad of opportunities.
Shannon, I thought the video of Erica was very natural. It almost appeared like somebody in the family was taking the video. It didn't appear to be contrived. It didn't. I didn't see any of Steven Spielberg's touches on it. Who did that video? Was there a lot of prep involved? Did you have a general idea of what you were going to cover?
The video was done by Jeff Reed. We do a lot of videos. I like them to be basically as rough as possible. I'm not looking for Hollywood. One of the things that I would comment to you about in terms of preparation of your client, I watched that video once with Diane before it was to be shown in court. I didn't go through with her my examination. My examination of her, aside from what I've already told you, was essentially what I would have done in the courtroom. Unscripted, very natural, working in humor where appropriate, changing the subject where there were reasonable segues to do so. I mean, you want this to be as natural as possible. In order for it to appear natural, it needs to be natural. The other thing that I wanted to say is that, and this has been said by others, but it needs to be stressed. When you're trying a case involving someone who's catastrophically injured, you want to stress all the positives. You don't want the jury to think that you're there trying to make everybody's life more miserable than it really needs to be. These stories of catastrophic injury tell themselves, and your job as an advocate is to stress the positive. People want to find and favor and award money to those who they think will do well with the money that's awarded, not for those who think, not to those who the jury feels are helpless cases and cannot be helped by the money that's being awarded.
Thank you.
If I may just add something to what Shana just said, the natural aspect of it, why things are shown. I recently sat on a case where 3 young African-American children, 2 boys and a girl, ages 9, 7, and 4, were abused and raped in a setting of a foster home. And the attorney videotaped all 3 children talking for the purpose of showing how well they would present themselves. The effect that it had was that they presented themselves so well that you did not believe they were injured. So you have to be very, very careful of what you're doing and why you're doing it. I mean, what happened to them was terrible. And the indication was that their lives may well be ruined unless they have long-term treatment. But as you watch these children, you did not get that feeling. So be real careful of what you're presenting and how you're presenting it.
Do you have some strategy that the plaintiff's attorney should have used? Can you compare that to some other case where there was a similar situation and it was
Well, I had one where they had it's difficult, first of all, when you're questioning a child, how you're handling it. You've got to be very delicate. These two gentlemen know how to do it well. You can't attack them. You ask them if they know what the truth is and what the truth isn't, and you then try to get a story from them. When there are situations, you might not even want them in the courtroom. You might have done it by deposition because the impact on the child is too great. But if the child is going to react based on your experience with that child, and you videotape that, you're going to get the reaction that you might need, but you never know how a child is going to react. So you have to be extremely careful in planning whether you want to do it with the child or not. You know the parents of the child, you know the child, and you have to make some very, very delicate decisions on what to do and how to do it.
In Abraham's case, he never talked on video. We have shots of him playing, having fun with his friends, and then I think it's probably, Erica is much a better advocate for telling about Diane's life than Diane's. That's, oftentimes you get the testimony about how hard it is, not from the plaintiff, but from the plaintiff's family members. And I can't think, I'm running through my head, I can't think of a single case where my client was a child where I've had them actually be interviewed in the video. Because you get that from other people.
Smart move.
Stand, you have to stand.
Do I have to stand?
Yeah.
Okay. Hi, my name's Elise Kramer, and I'm the LLM and International Career Counselor here at the law school. But prior to that, I worked in the Claims and Civil Rights Department of the City Law Department for about 9 years, and I saw a lot of cases. And in general, our cases were pretty low value for video, or we would be a co-defendant on a bigger value case. But one thing that came up, and I think would be useful for folks who don't have a lot of money to spend to think about is there video out there involving your case already? And every once in a while that would happen. I had this case where a young lady claimed to have gone to a rap concert at the Dell and had been injured going on stage when this particular performer was on. And during our investigation, it turned out the Dell had videotaped the whole concert. And so at the arbitration, I had someone come say, is this it? We played it, and I said to the plaintiff, stop when you come on stage. Tell us when you get on stage, we'll stop the video, and we'll take a look. And of course, we did that because she never came on the stage during the entire performance. And so, and there are a few other times. So every once in a while in a case you'll find, so much is videotaped now. So many things actually are caught on tape. And it's worth it to kind of think about what aspect of your tape might already be videotaped.
Found video. We call it.
Found
video.
the outtakes.
The other thing, of course, is that the cost of cameras is going down.
Yeah.
You can get little video cameras for $100 from Target that you could give to a client to do a sort of video diary of the client's life. Well, Alex has one of the little cameras that we have. It costs, I don't know, $600, but it's perfect for doing a video diary, giving it to a client to film what's going on in the client's life. It's basically point and shoot. The only thing that I think you can do is zoom in and zoom out. And it would be ideal for a kind of day in the life on the cheap from the vantage point of the victim. Next question.
My name is Margie Smith, and my background is in broadcast television. And I think that video used in the legal arena, it brings up some very interesting questions. One of which is that visual media, it's been demonstrated empirically that visual media acts upon the brain a lot differently than, for example, an oral argument does. And it's processed by the primitive brain before it can be analyzed cognitively. And I'm wondering if this has arisen as an issue in the introduction of visual evidence in the courtroom. You know, have you ever found that judges just summarily reject visual evidence in the courtroom for that reason? Has this issue arisen at all to your experience?
Well, I don't think that judges are in a position to reject the evidence for that reason or anything like that reason. There might be other reasons to reject the evidence. If a film, for example, didn't depict that which it was represented to depict, it could be rejected. There have been many situations where there have been reenactments of accidents where those films are not admitted because they're not a true reenactment. I'm not an anthropologist or a biologist. I'm a trial lawyer, so I would have to speak in the terms in which I'm accustomed. But for those who have, pardon me, specialized training in other fields, you might adapt what I'm going to say to your own lexicon. This is how I look at it as an advocate. I look at it as an arc. And the arc is that I want to, in this order, I want to talk about my client's issues. I want to show the fact finders still photographs. I want to then show them a videotape. And then I want them to meet my client and if possible have my client testify. So in this case, Erica Pratt would have testified after her mother was finished. I believe that what happens is that the jury gets drawn into that process, first by the words, then by the stills, then by the video, so that they continually want more and more from me. They're more and more interested in seeing what this is all about. My partner and I call it the arc. We look at it as an arc in the courtroom. I don't pretend to have invented this. I'm not sure who did invent this, but this is my own kind of view as to how the fact finder will be most interested in having the evidence presented. It just seems to work.
If I could just mention, you mentioned testing. There have been any number of psychological tests as to what produces a message. Words represent 10%. Tone, maybe 20%, and body language represents the balance, 60 to 70%. A tape, a video, is body language. And that's what you got in the Erica presentation. You had body language. That conveyed the entire message. So I think any judge, if a foundation is laid, and Shannon mentioned this, and all you have to do is lay out the parameters of how it was done, what it is, very few judges will reject it, and I think if they do, they're probably in error.
And I think it's growing much more accepted. You know, Professor Austin and I participated in a program up at Fordham. She was visiting a professor up there, and there was a defense attorney who was making exactly your argument, that having this visual medium available to the plaintiffs to depict what so powerfully what had happened to the injured person just tilted the balance so far out of whack that it overwhelmed and it should be precluded, where the prejudice outweighs the probative value would be the way you would come in. And those objections are being made, but I don't, oftentimes, the instinct as a trial lawyer is to jump up and go, objection, it hurts my case. And then you think about between the, before you say those words, you think about what's the legitimate basis. I don't see it going anywhere though. If you've got the foundations, if you've done it in the right way, the fact that it's powerful is not going to be a basis for precluded, although I think it was an attorney from Chicago who was speaking about this. She's on a campaign as a defense attorney to file motions in limine to preclude these type of day-in-the-life films, shots of video, physical therapy, so that because she just thinks it tilts the balance so unfairly.
Have those objections been sustained to your knowledge?
She was optimistic, and I don't think it would fly here.
I have never gotten away with it. I've tried many times. A day in the life, I have never been able to keep it out.
Inflammatory videos, like other forms of inflammatory evidence, might be stricken. But the academy is becoming much more interested in ways of telling stories that draw on traditional storytelling techniques, and pictures are clearly part of that. We're also becoming interested in the role of emotion in law practice and in legal decision making. So we're ahead of you in terms of trying to understand the mechanics of these things and making certain that we draw on them in the right way. And I think, I keep calling him Judge Adelstein, he's almost a judge. His emphasis on the respectful nature, the dignity, I think those are values that visual legal advocates are incorporating, not only because of ethical concerns, but because they want to make effective videos. So I think the concerns that you've raised are being responded to.
One of the things, again, I mentioned that when we first started videotaping depositions, the concept was to have a fixed lens. And the only time you could really keep something out is if in their presentation they have used effects. We heard Steven Spielberg before. That is not what was done by Shannon. If they use it in an effect way, you may be able to keep it out. But if it's a true presentation, as Erica's was, there is little chance that it's going to be excluded.
Thank you. They have to come to the microphone. So.
There's a bit of a crowd there.
Oh, okay.
I'm Ed Rock, I teach here. Those were the video, the day in the life and the clips that Marty showed were unbelievably affecting. And I want to ask you to try to step back a little bit from that, because they were, especially the day in the life came off just as you wanted it to, as natural, dignified, simple. But as any, as any such work of art requires, to achieve that sort of naturalist simplicity takes a tremendous amount of insight, art, and expertise. And the same with Marty's clips. They came off just the way you wanted them to come off. And that takes, when you just turn on the camera and film it, you don't get that, right? That's the product of a great deal of sophistication. So I want to ask you, if you could, to reflect a little bit on, your role as producer, filmmaker, and the visual vocabulary that you're using, the way in which, when you go about your daily life and, are looking at movies, films, videos, documentaries, what lessons you take from that and how you bring that to bear in creating these films that achieve this simplicity and honesty that you want to achieve.
Well, I believe that Yogi Berra was asked to explain how he was able to hit so well, and his answer was, just watch me. He really couldn't articulate an explanation for how to hit a baseball 400 feet. I can't really articulate what goes into being an advocate for doing it for 23 years as I have. I would say come to my class for the 26 hours that I have with my students to talk about advocacy. I think that if I could distill it, though, to the 30 seconds I'm going to take to answer the question, I think that the first thing is truth. So if truth is the guidepost, then everything else kind of falls into place relatively naturally. And I'm not interested in puffing. I'm not interested in anything other than a fair depiction of what's occurred. If I had to criticize that video that we did, this might illustrate something to you, I would have gotten rid of the dissolves from one part of the day to the other. And I would rather just do a jump cut from one day to the other, because a jump cut is rough and unprofessional and a home movie-like, and the dissolves are sort of expensive and professional. I just as soon have the jump cut. But I wasn't going to mess around with that film. To tell you the truth, this is a terrible admission to make, but I didn't see that film until a couple weeks before trial. There's just too much happening in the law practice that I'm involved in for me to watch those films. I mean, my folks in our firm know how to make them basically, and I don't micromanage it, and they know that for me, it's got to be 20 minutes, no longer. But, you know, I don't get into the jump cut issues. But to me, if I had to criticize the film, I would say that just is a little bit too Hollywood for me. And it gets back to me, which is the main goal, which is truth.
Having been in the motion picture business, there's a world of difference in the production of a film and a day-in-the-life film. When you were writing a script, you're looking and thinking of how many people are on camera, what the camera angles are, what the lighting is, and you very carefully plan your shooting schedule. It is done with great thought. When you are doing a day in the life of, as the Erica film showed, it was extremely natural. You do not want to plan it, because if you're trying to plan it, you're trying to position people, it's going to ruin it. You're just not going to get the effect. And Shane and Marty, who do these, have done them so many times, they have the feel. You know, when people ask you the value of a case and you give them a number, where did it come from? Well, my stomach. Well, that's years of experience. While doing this, they know what they want to show. And they want to make it as natural and unplanned as possible. So I don't think the idea of planning it or lighting it, you just, as I said before, you want the surroundings to be right and use it in that fashion. And I think that's the difference.
When I finish the first interview with the client for a matter that I'm going to undertake, I am starting to work on my closing argument. From that moment on, it's running through the back of my head, oftentimes much to the annoyance of my wife. But I just think about it, and I think what I'm going to say in the closing, and I think about what the defense is going to say in the closing. And what I do in anticipation of making like a settlement brochure is I just distill that down to the very core issues. What are we going to be arguing about here? And focus on those, and then, you know, echoing what Shannon said, you know, you want to never overstate, be completely honest, and let it all come out. And you know, there is a school of thought about, you know, some people turn in expert reports for complex products liability cases, which are 3 pages long, and say that the product is defective, the defect was the cause of the accident, and they were bad boys. That's it. I oftentimes will submit expert reports that are 20, 30 pages long, which spell out, you know, and this is what my expert's going to show at trial. And I am, you know, when I get done with a discovery stage of the case, I know what I'm going to do, and I want to convey to the other side, I know what I'm going to do, and hear what it is, and you can't do anything with it. I mean, you want to convey that sort of confidence in yourself in a way that's very clear, very apparent, it's going to come through it, and that's what I try to do. As to how do you know which, I mean, you know, how to get a witness to say things, God, I wish I knew how to do better on that, you know, it's trial and error. You know, I've done 50 to 70 of these, and so which means I've done a good portion of my life doing interviews for this, and you just get a feel. And you know, I've only been at Raines for about 3 years now, but I've now got almost every trial attorney in that firm doing these. You know, I just sit over their shoulders and, you know, as they do them and help them craft them and all sorts of fabulous things. The comment was about, you know, like expense. One of the attorneys represents a young woman, her eye muscle was severed in surgery, admitted malpractice. You know, there's not a contest as to that. It's about what the damages are. She now has double vision. So you get 2 cameras mounted at the same distance apart as the eyes, and you create double vision, and you walk people around on the video with what it's like to live with double vision. Boy, I mean, that took one morning, a couple $100, and you played it to the defense attorneys, and they just were like, oh my God. You know, by the time you finish watching it for a minute, you're nauseous. And this is what the woman has to live, you know, at the age of 23, got to live with for the rest of her life. So.
What's interesting, if I could just add to that, I represented a plaintiff once.
Just once, Ed.
It was a wonderful experience.
You found the cure.
It was a removal of a wisdom tooth and the lingual nerve was cut. And this woman had half of her tongue permanently as if you had Novocaine. I don't know how I would have filmed that. I mean, there's certain things you can't show. We settled it at what I thought was a reasonable number, but this was the most beautiful woman I have ever seen in my life. Don't tell my wife I said that. But I was concerned what the jury would think, you know, give up half a tongue to look like that. But you don't know how to make certain presentations. What they did here with the double vision is really an outstanding way to present it. Some things cannot be presented.
Next question.
I have questions that may be for later in the day, so you'll tell me. Art Reed, Friends of Farm Workers. The first one I think does fit with what you were talking about, so let me just focus on that one first, and it's the outtakes, the news broadcasts. What's your experience with being able to get not what's broadcast over TV, but raw footage?
They won't produce it voluntarily, you have to do it by subpoena.
Yeah.
And how long is it preserved?
At local stations here, at least a year.
Okay. Critical question is practical. So by subpoena, you've been successful in getting it?
I have.
And
If you want to, I can tell you who's the general counsel for accepting the service on any news broadcast.
okay. And do you usually like give notice in advance that this is something you're going to want so it doesn't get destroyed? Or
Yes,
just...
absolutely. I'll send out preservation of evidence letters. If I think there's news coverage, absolutely. As soon as we get involved.
The outtakes the other way around. You're talking about following people around early on in the case. Are those fully discoverable by the other side? Everything that you've done along the line? I assume the answer is yes. Right?
I think it is. Yeah.
And do you
routinely
routinely get requests to produce it all?
Never.
Okay. People are thinking.
No defense attorneys in this room, is there?
Okay, the other area is actually the one I think maybe for later today, and it actually follows up on Mr. Pennington's questions. It's a lot of what we do is workplace related injury or workplace related issues, and it's access. How do you get particularly the non-scripted, emotion? Yes, you can get an inspection, but the inspection, the employer is going to control the circumstances in which they're there. How can you get access to film the kind of circumstances? We've had housing situations. Housing, yes, you may be able to get in and get some access, partly because we've got some legal rights potentially to get into that housing. But the workplace, we really don't have that. And in fact, we've had cases in which the audio tape is in violation of the state wiretapping statute for the worker to have a record of the speech of what the employer has said. And so presumably, you could have similar issues if you have a worker on their own. Lots of people do now have cell phones, and those cell phones maybe even have video capacity, but it may be a violation to use those phones. So any experience with that issue and how it plays out?
These are all real practical problems. And there's no miracle. In the Manuel Carrion's accident, I had 11 undocumented Mexican workers who said facts were A, that the machine arrived without the guards on it, and I had 6 white mechanics from the defendant who all said that the guards were on it when it left their plant. Manuela said her novenas, and from the skies above, an independent video was just taken by chance, somebody passing through, looking at something else, caught it on the tape at the defendant's facility with the guards off. That's not great lawyering, that's just blind luck. Sometimes you get blind luck, sometimes you just gotta work around the situation. But illegal wiretapping, yes. Recording statements without the other party's consent in Pennsylvania, big problem, very big problem.
There's a rule of civil procedure that provides for the right to go in to a premises and inspect, and I don't recall the exact language, but surely...
Yeah, federal rules equivalent to Federal Rule 30.
Okay, so surely a court when presented with a motion to do such a thing would permit there to be videography.
I think the problem is its control. I mean, when clearly the employer, if you have such a motion, the employer is going to be able to control the circumstances under which you're able to see, et
The
cetera.
point that I made half an hour ago, which is you may not want to go in there for that reason.
We are just about out of time. Let me give the three panelists, a final go-round to make final comments on what you see as we project forward to this afternoon. This role, this increasing and important role of video legal advocacy, and both how you see it developing in your areas, but how you also see it applied elsewhere.
Well, I would just say that you've heard probably 3 or 4 dozen different applications of video advocacy, videography, and probably we could think of several more in a couple of hours. I did want to answer a question that was asked of me earlier about why was this case settled when it settled, and that is that Erica Pratt's damages were well understood by the defendants. I believe that the video played a role in their assessment of those damages, so I don't want you to think that that wasn't a factor in the valuation of the claim by the carrier. But the circumstances of what occurred on that day in that classroom were hotly contested. And they wanted that case to be tried. They wanted to see if they could win that case. And it was apparent to them after 4 days of trial that they were not going to win that case, which is when they decided to settle the claim. I also would like to advise you, because this is a very big part of what Marty and I do, that the Pratts were not willing to settle that case unless the university made very substantial changes to their policies and procedures regarding the training of their police force with respect to medical emergencies. So that was a part of the resolution of that claim.
I think the visual field, it's an exciting time. I mean, I love going to the office and working on these projects and trying to be creative. And with the advances in technology, it's cheaper, it's faster, it's expanding. We're now talking about doing videos that have sub-programs. If you're interested, if you think you're going to win on this, press this button here and we'll show you while you're dead there. But we're not going to fit it into a 20-minute video. We're going to make them easier for defendants to get to. We're going to put our video settlement brochures on a website, let them stream there, and they can log in. So anybody who wants to see this on the carrier side, the defendant side, can get access to it. And it's just, more than can make my head spin in terms of potential out there, not only in personal injury litigation, but I've seen it used in contract disputes, business litigation, where you've got issues that can be refined and presented in a visual medium. Sky's the limit. As Shane had said at the beginning, if you get bitten by the bug of being a trial lawyer, it is sometimes a nerve-wracking life, but it is interesting and rewarding, and you go to work and you know that you're going to be doing well by somebody, even if you're on the defense side.
Times have changed so dramatically. When the dean said he was here a half a century ago, and Shane had said he was here in 1984, when I came here we had a hitching post for our horses outside. When I was working in videotape when it was first being developed, and you edited videotape like you did film, we had to splice it. And you had a splicing machine and you put it together and you glued it and you did all of those things. Today's equipment is incredible. I don't know what the equipment's going to be tomorrow. It's just amazing what can be done. One of the things that I would like to see done, I had the good fortune of trying cases in about 13 states around the country. I was not in the Philadelphia courtroom. There was a 12-year period I was not in the Philadelphia courtroom. I don't think anybody knew me at that time. But some uniformity of rules would be very helpful. Here in Philadelphia, you know what you have. And probably in the 5-county area around Philadelphia and in Pennsylvania, you have a pretty good concept of what you can and can't do. I have no idea where this is going, but it is becoming so valuable and so important in the preparation and application in your presentation for your client, whether it's on the defense side or the plaintiff side. I just think it's unlimited, and if it's done in good taste, it's going to be used, and it's extremely exciting and helpful.
let me ask everybody to join me in thanking our panelists for a wonderful